Under Section 93, exclusion of evidence to explain or amend ambiguous document. Section 93 to 98 deals with the rules for construction of a document with the aid of extrinsic evidence. Section 91 and 92 define the cases in which documents are exclusive evidence of the transaction which they embody. Section 93 and 99 deals with the interpretation of a document by oral evidence. There are two sorts of ambiguities of the words. The one is ambiguous patent, another latent. Patent is that which appears to be ambiguous upon the deed or the instrument. Latent is that which seems to certain and without ambiguity for anything that appears upon the deed or instrument, but there is some collateral matter out of the deed that breeds the ambiguity. A good test of the difference is to put the instrument into the hands of the ordinary intelligent educated person. If no perusal, he seems no ambiguity, but there is nevertheless an uncertainty as to its application. The ambiguity is latent. If he detects the ambiguity from merely reading the instrument, it is a patent ambiguity. Thus, in illustration, the blanks would be patent ambiguities and they could not be filled in by parole testimony as to the intention of the parties. In the illustration to Section 95, no one could detect any ambiguity from merely reading the instrument. The ambiguity does not consist in the language, but is introduced by extrinsic circumstances. This section deals with the patent ambiguities. If the language of the deed is on the face ambiguous or defective, no evidence can be given to make it certain. The duty of the court is always interpretation, to find out not what really was the intention of the parties as distinguished from what mere words express, but merely to find out the meaning of the words used by them. Under this section, it is the language of the document alone that will decide the question, and it would not be open to the parties or to the court to attempt to remove the vagueness by relying upon any extrinsic evidence. Such an attempt would really mean the making of the new contract between the parties. In a contract of transport made with the Food Corporation of India, the column of transport charges was left blank. The attempt of both the sides to give evidence of the oral agreement on the point was not accepted, since the blank space cannot be filled by oral agreements. The charges for the services rendered may be recovered under Section 70 of the Contract Act. Extrinsic evidence of every material fact which will enable the court to ascertain the nature and the qualities of the subject matter of the instrument, or in other words, to identify the person and things to which the instrument refers, is admissible. Thus, where there is a written agreement to deliver a quantity of grains at a particular time, parole evidence is admissible under certain limitation to show what kind of grain the contracting parties had in their contemplation at the time when the contract was made. Section 94, exclusion of evidence against application of documents to existing facts. The words of a written instrument must be construed according to their natural meaning, and no amount of acting by the parties can alter or qualify the words which are plain and unambiguous. No principle has ever been more universally or rigorously insisted upon that those written instruments, if they are plain and unambiguous, must be construed according to the plain and unambiguous, unambiguous language of the instrument themselves. Under this section, evidence to show that common words whose meaning is plain, not appearing from the context to have been used in a peculiar sense, have been in fact so used, is not admissible. Where the language in its ordinary sense properly applies to the facts without any difficulty, evidence to show that it bears a different meaning will it be rejected as it contradicts the document. Where in a lease agreement with the government, payment of interest on arrears of a rent was stipulated, but mode of payment was not stipulated. The collector was not prevented by section 94 from deciding the mode. A promissory note was not allowed to be explained away as a deposit. This section applies only when the execution of a document is admitted and there are no visiting circumstances against it. Oral evidence of a witnesses in proceeding before the board was admissible. Section 95, evidence has to document unmeaning in a reference to existing facts. Where the language of a document is a plain in itself but is unmeaning in reference to existing facts, evidence may be given to show that it was used in a peculiar sense. It is based upon the maxim falsa demonstratio non necet, means a false description vitiate the document. Section 97 is a part of the rule in this section, and both the section must be read together. The illustration to this section shows that if A sells to B my house in Calcutta, and if A has no house in Calcutta but has a house in Howrah, of which B has been in possession since the execution of the deed. So these facts may be proved to show that the deed relates to the house in Howrah. It describes the land sold by wrong survey number. Extrinsic evidence is admissible to show that the land insist to be sold and actually sold and delivered were land bearing the different survey number. Where sufficient description of a premises is set forth by giving the name of a particular field or otherwise as a false description added thereto, example mention of a wrong survey number, may be rejected. Under section 96, evidence as to application of language which can apply to one only of several persons. Where the description in the document applies equally to any one of two or more subjects, evidence to explain its language is admissible. Where the language of a document, though intended to apply to one person or things only, applies equally to two or more, and it is impossible to gather from the context which was intended an equivocation arise. Example, when the same name or description fits two persons or things accurately, when the same name or description fits one exactly and the other, but tolerably when the same name or description fit two objects equally, but the subject to common inaccuracy, provided that inaccuracy may be mere blank or applicable to no other person or things. This section modifies the rule laid down in section 94 by providing that where the language of a document correctly describe two set of circumstances but could not have been intended to apply to both. Evidence may be given to show to which set it was intended to apply. Here the language is certain. The doubt as to which, if similar person or things the language applies, has been introduced by extrinsic evidence. Under section 97, evidence as to application of language to two sets of facts, to neither of which the whole correctly applies. This section based upon the maxim falsa demonstratio non necet. It is only an execution of the provision of section 95. Section 95, 96 and 97 all deal with the latent ambiguity. Where a written instrument, the description of the person or things intended is applicable with a legal certainty to each of several subjects, extrinsic evidence including proof of the declaration of intention is admissible to establish which of such subject was intended by the author. The rule rejecting erroneous description not substantially important is applicable only where there is enough to show that intention clearly. The illustration to this section shows that if A agrees to sell B my land at X in the occupation of Y, and A has land at X but not in occupation of Y, and has a land in the occupation of Y but it is not at X, evidence may be given to show which was intended to be sold. Another common case is where the land within certain boundaries is sold and is wrongly described as containing a certain area. The error in area is regarded as a mere misdescription and does not vitiate the deed. The maxim falsa demonstratio non necet applies. Under section 98, evidence as to meaning of all illegible characters, etc. Evidence as to the meaning of illegible character, example Shatton writer's note, or a foreign absolute, technical, local, provincial expression and of words used in a peculiar sense may be given. In such cases, evidence cannot properly be said to be vary the written instrument. It only explains meaning of the expression used. Mercantile usage has given special meaning to many ordinary words. Evidence of the meaning which these words bear in a mercantile transaction can be given under this section. The principle upon which the words are to be construed in instrument is very plain. Where there is a popular and common word used in an instrument, that words must be construed prima facie in its popular and a common sense. Words of a technical or a legal character, it must be construed according to its technical or a legal meaning. If its words which is of a technical and scientific character, then it must be construed according to that which is primary meaning, namely its technical and scientific meaning. But before you can give evidence of the secondary meaning of the words, you must satisfy the courts from the instrument itself or from the circumstances of the case that the words ought to be construed not in a popular or a primary significance, but according to its secondary intention. Where the point in a dispute is as the meaning of a particular word is in the document, evidence may be admitted to show in what peculiar sense that particular words was used. An extrinsic evidence, including the evidence regarding the subsequent conduct of the parties, is admissible to determine the effect of the instrument as well as the intention of the parties. If the government grant up a land which involved question of interpretation of the government orders, that was held to be a question of fact. The document was written in an uncommon foreign or a Persian language. It was held that the court could rely on ability and knowledge of the judge hearing the case, decipher such language and the meaning of the words like huzur or bujurgan, Maurice, biradari, minjumle, requisite in the context.